Well, the file name is short note on behalf of SG. Well, that's if it can be. I'm not going to read the entire note, my lord, whatever is relevant.
It's there in the link also. What is the link?
You have it, Samir.
It's in the convenience compilation also. The link that we've sent,
Ah,
it's been added in that.
yes, sir.
If, in fact.
We're just uploading it.
Yes.
So on the lighter vein, on this side, you are trying to make our task easier by saying that there's only one issue and not
Well,
two.
that's how, my lord, our understanding of, my lord, the chronology is.
And then go to the reference.
Kind.
That's the referring order also, if your lordship looks at it. It's only the issue referred is that
If the
material resources of the community, whether they include private property or not.
fact, if the learned solicitor permits, let
But
us.
that issue will arise
That's right.
if we come to the conclusion that 31C is revived.
Right.
Right, because
That's
what
a
31C,
separate,
just
I'm
look at
not
it
saying
this way.
your lordship is right. Issue is there, but that's not referred because that's already covered by so many judgments.
The question is the ambit of 39B will arise provided 31C exists today. If 31C does not exist, then there's no question about the ambit of whether that will include
39B, my lord, can still survive, my lord. It's an independent provision as a directive principle. The only
31C.
But that's not referred.
Correct,
The lordship
Manoj.
may expand the reference, that's another thing, but it's not referred.
It's in fact covered by the NJC judgment, because if there were no doctrine of revival, half the judges of our court wouldn't be here today.
No, but otherwise, my lord, just a little,
It's covered, they've considered it.
my lord, suppose,
Anyway, now the note is uploaded. So we
my
can
lord,
just see
please
what
kindly
the
come to, my lord, para 2, at page 2.
page 2.
Page 2, my lord. Lord, this was the 1996 Property Owners Association, the first judgment I am referring to. I am not reading everything, para 2. The said reference, it was argued by the petitioners that Article 31C does not survive in the Constitution anymore. Your Lordship, sir. Anymore after the decision in Minerva Mills. On the contrary, it was argued on behalf of the respondent that only a portion of 31C, as inserted by the Constitution 25th Amendment, was declared unconstitutional in the judgment in Keshavanand Bharti, and remaining portion would remain. Lord, I am pointing out that the court was conscious of these two provisions and a possible interlinking. Lord, thereafter, your Lordships may come to, my Lord, 3. Sub-third paragraph, my lord, unnumbered paragraph. The judgment in Minerva Mills struck down section 4 of the Constitution 42nd Amendment on the basis of the same and subsequent judgment in Vaman Rao, Sanjeev Coke Manufacturing Company. It was argued that it was obvious position in law that 31C, as it stood after the judgment in Keshavanand Bharti, would remain in force. In essence, the argument of the petitioner at the said time was that the doctrine of revival, as it applies to ordinary statute, would not apply in India to constitutional amendment, and their subsequent declaration as unconstitutional on the touchstone of basic structure of the Constitution, etc. Lord, please come to para 5. When the said matter came up for hearing before 5 honorable judges in the judgment reported in Property Owners Association, I have given the page numbers, rather than dealing with the question raised concerning application of doctrine of revival and its applicability to constitutional amendments in India, which had a bearing on Article 31C, the court dropped the said issue and referred a separate issue to a bench of not less than 7 judges. But I have quoted from that honorable 5 judges bench. Having heard the counsel at length, we are of the opinion that the views expressed in Sanjeev Coke require reconsideration. Keeping in view the importance of the point in issue, namely the interpretation of Article 39B, it will be appropriate if these cases are heard by a larger bench of not less than 7 judges. My lord, then it comes, my lord, before the Honorable 7 judges, my lord. My lord, 7 judges, my lord, in state of Karnataka versus Raghunath Reddy. My lord, there were 2 opinions delivered, my lord. One by my Lord Justice Utwalia, my lord, who was in majority 4, and minority by Justice Krishna Iyer. But Justice Utwalia categorically notes that though we are not touching this issue, we are not approving or we are not concurring with the minority view merely because we have not touched upon may not be treated as our having concurred with that view. Now, para 7, the reference of 5 judges in Property Owners Association, that is 5 honorable judges, therefore notes that the judgment in Sanjeev Kok has adopted the interpretation of Article 39B as provided by Justice Krishna Iyer in Raghunatha Reddy on the basis of the same.
Ranganath.
I'm so sorry. Ranganath, my apologies. Ranganatha Reddy. On the basis of the same, the 5 judges, 5-judge bench in the Property Owners Association opined that the views expressed in Sanjeev Kok concerning the interpretation of Article 39B requires reconsideration and only referred the said issue to a larger bench of not less than 7 judges. Now, my lord, 7 judges, my lord. Para 10, your lordships can come to. During arguments before the said bench, a judgment of 9 honorable judges in Mafatlal Industries was highlighted on the issue of interpretation of Article 39B. After taking note of the same, the 7-judge bench at para 5 referred the following question to a bench of 9 honorable judges. Having given due consideration, we are of the opinion that this interpretation of Article 39B requires to be reconsidered by a bench of 9 learned judges. We have some difficulty in sharing the broad view that material resources of the community under Article 39B covers what is privately owned. Therefore, the only issue before the present bench is whether the phrase material resources of the community under Article 39B covers what is privately owned. Despite the said obvious position, the petitioners have in great detail made submissions on whether 31C survives or in the constitution or not. But that's why, my lord, I am pointing this out at the outset. Their written submissions, my lord, give details. In this regard, it is submitted that apart from the fact that said issues stand concluded by multiple judgments of this court, including judgment in Keshwanand Bharti, which specifically upheld Constitutional 25th Amendment Act, it is clear from a reading of reference order of 5 judges and 7 judges in present proceedings that the said issue has not been referred to a larger bench of 9 judges. Then 13. The petitioners have in great detail further placed the challenge to a new provision of MHADA Act and specifically Chapter 8A of the said Act. It is submitted that constitutionality of a state act and individual provisions of the said Act, which would involve application of various other constitutional principles and fundamental rights, may not be adjudicated by a larger bench of 9 judges, as the same may have grave repercussions, etc., etc. And at the end, page 16, my lord, this is what, my lord, our understanding of the reference is. Page 16, my lord. Only issue concerning the interpretation of Article 39.
Just 1 second. You just be taking us page 16 or
16, my lord.
page 16? Page 16.
16. Page 16 is our understanding, my lord, of the reference, my lord.
Therefore, it is submitted.
Therefore, it is submitted that only issue concerning the interpretation of Article 39B and whether the phrase material resources of the community includes private property or not has been referred to the present bench of 9 learned judges. The interpretation of Article 31C or its revival or non-revival has not been referred, and the validity of this act is, my lord, not referred, my lord, because I believe Bengal also has a similar act and they are also here.
An intervention by Bengal.
So they would also, we will be supporting on.
Mr. Solicitor, let's go in the reverse way. We'll tread the path of least resistance. Insofar as C is concerned, where you say don't decide the validity of the MHADA Act in a combination of 9, that there may be some substance in what you say, subject to hearing the other side, of course, that that will turn upon, analyzing the individual provisions, looking at the impact of various decisions. And ordinarily, that's always left to the regular bench.
Regular benches.
That's one aspect. Now, coming to B, we see that.
Would your lordships like to read the reference order, my lord?
The reference order immediately. But according to you, the fact that 31C, the principle that 31C in its original form stands revived as upheld in the 25th Amendment, upheld in Keshwananda. That is now, according to you, that has been the position in our law. Don't unsettle it, because you want 31C to remain there as a government. Obviously, we understand why.
Otherwise, also, my lord, kindly take it absolutely logically without going into the merits. Suppose someday, after 40 years, some mad parliament deletes part 3.
Because if we come to the conclusion, that 31C does not stand revived, then of course that will affect a whole lot of legislation.
My lord, suppose I am giving a very extreme example. My lord, suppose some parliament, in its wisdom or lack of it, deletes part 3, the deletion comes before your lordships. Your lordships sets aside the amending act. Now, would there be a vacuum? The answer is no. The fundamental rights will come back. The part 3 will come back. It's as simple. But kindly come to
point to be considered.
Right.
Yes, sir.
That's it.
Lord, volume 5.
If I may
Lord, volume
submit,
5, the reference order.
Can
Let-
we do this?
if I-
Now, let's hand it over to Mr. Parekh.
No, only-
You've got your point. Let him read the reference order and then tell us
Lordship,
whether both these
absolutely.
issues
Let
arise.
me just place what the issue is, what are the reference orders, for how it comes
You've
here.
got your point now,
Lordship.
but let's not preempt his argument. He can make that argument. Once he makes an argument on the scope of the reference, we feel that we should allow you at that stage to respond to him. We'll call upon you
Set.
briefly.
Set.
What is sought to be suggested additionally is that if this court were to hold that 39B is confined to only natural resources and not to any other resource, then the 31C argument may not be necessary.
No,
So unless the court crosses this.
No.
If the contrary is held,
Yeah.
then
Our court has said that, well, 39B would not appear to cover private property, where the material resources of the community would extend to private property or otherwise.
tentatively, my lord, reference does say, my lord, that
That's right.
we are not able to subscribe to that view. That's what my lord is saying.
But let's hear Mr. Parekh, so let him open and then we'll get back to you.
Certainly.
Lordship,
Yes,
I'm
Mr.
grateful. In fact, State of Maharashtra first filed detailed submissions on all the issues, then Wiser Council probably prevailed. They've withdrawn that and now filed this note. Lordship.
Hold it again.
Gotcha. So may I just indicate, my lords, just to start with just a little background, and I'm appearing in 6 petitions before my lords, which challenge, 5 of them challenge chapter 8A, we are in appeal, and there's an independent
So
writ.
you will be
And-
the argument, the initial argument with the 6th matter.
Lordships,
Then
lordships.
who will follow Mr. Adhyatna? You'll be
Mr.
arguing in,
Andhya and Mr.
I am addressing your lordships on 2 issues. Lord, actually the issue of 31C. Lord, I have three broad ways I've prepared. I want to give your lordship a brief legislative history of it. I wanted to point out why my learned friend, the Solicitor General, is in fact incorrect. Lord, the question of 31C arises both as a point of reference. It arises out of the Coehlo case, which is expressly referred to your
it
lordship.
arises out of?
Coehlo case. Coehlo.
Coehlo.
But my learned friends repeatedly correct me on the pronunciation, on the Coehlo case. And it even otherwise arises squarely, Lord, in this constitutional challenge, as I will show you, Lordship. So, Lord, the reference point is the least of.
We were only on what is the lineup of counsel on your side, so it's going to be then.
My lord, we are sharing the submissions. I'll be going on 2 aspects of the matter, my lord. The first aspect of the matter is, can they at all seek the protection of 39C in view of the proviso to 39C?
All right.
I'll be arguing.
Right
Those
now,
are the
let
points
Mr.
which
Parekh
I'm-
start. We just want to know who are the counsels.
Yeah.
We know about
We are-
time and everything. So
Yes,
that-
Just so that it's clear to your lordship also, Lord, Mr. Parekh's, Lord, is giving the opening remarks. Lord, he will take about 1.5 hours. Lord, subject to what happens here, Lord, he might take your lordships to lunch. Lord, after
Then you
that,
will, after lunch, you
Lord,
will
I am
start.
proposing to start after lunch.
All right.
And Lord, my rough estimate is 2 sessions,
All right.
roughly.
My lord, I'll be opposing the intervention application of State of West Bengal.
All right.
Sorry to interrupt. I'm appearing in one of the.
Why don't you all do this? Put your appearances down on a slip of paper and give it to the court master so that he'll circulate it to all of us.
The matter arises from the West Bengal case. While it was pending before 5 judges bench, the bench itself said that it would take up our matter after this
After this.
reference is over. Therefore, we want to intervene.
All right.
My lord,
Anyway, my lord,
there is one-
so far as states are concerned, my lord, everyone, my lord, assistance coming from everyone. I am not opposing
My
state
lord,
of West
there is
Bengal
one
or any state's intervention.
which I would like to
Assistance
take for
should,
kind consideration.
Now,
I will come, what I say.
Sorry, not right now. You know,
11th schedule and 12th schedule.
please sit down. I will hear Mr. Parekh first.
Just, my lord, just to begin with, just to give a little summary of what are the issues and what is under challenge. There are 6 matters.
The microphone.
I'm grateful. So there are two sets of challenges. One relates to Chapter 8A of the MHADA Act in Maharashtra. It relates to the island city of Mumbai now. And the second challenge is to the Maharashtra Rent Control Act, which is in writ petition 660 of 1998. And one of the reasons, of course, why we filed a writ petition is that there is an earlier judgment of this honorable court, Malpe Vishwanath Acharya, which has already held that the Bombay Rent Control Act was void, the provisions relating to rent. And following that, the court adopted a method where they did not strike down the act, but stated that a new act should be formulated, which was in the process, and specifically holds that if the new act does not take care of the issues raised in Malpe, then the new act would also be void. So that's the background.
The Maharashtra Rent Control Act is in writ petition, you said 660 of?
660 of 1998. Now, my lords, we had in fact the two matters, Malpe Vishwanath and this one, actually were tagged together at one stage. They were detagged and the Malpe got decided. And this, of course, is still awaiting my lord's decision. Now, just to give a background, these petitions relate to temporary provisions which were brought in during World War II, 1939, first with effect from 1st January 1939. They've continued all these time. There have only been, so to say, 2 increases in rent, while the wholesale price index, and we've given that data, has risen from 7 to over 1,000, but the rents have remained frozen. Before Malpe case, there was only 1 increase of 5%, plus some increase relating to repairs which were carried out, etc. And thereafter, once the Maharashtra Rent Act has come in, then another 5% provisions are there. Now, because the rents,
our court followed Justice Venkatramaia's dictum in Motor General Traders,
Lordship.
saying that a law which is valid on the date of its enactment
Lordship.
may cease to become valid by a flux of time.
Lordship.
And therefore, they said that a World War II law which froze the rents as of 1/9/1940
Lordship.
would cease to have validity by just the lapse of time. You can't deprive landlords of the right to demand fair rent.
Great. Lordship.
And the court gave a certain time window.
Correct.
That's when the Maharashtra Rent Control Act came.
Correct.
They took the cutoff date as 97, right?
They took, but because 97,
87,
87,
but a 4% increase every year.
correct. Lordship. But because the rents were already frozen for the premises, it actually went back to January 1939, because from 39 to 87, there had been no change, except 1 increase of 5%. So that's a broad challenge. And in fact, so that's the Rent Control Act. And if I succeed on that, in fact, my second challenge becomes easier, because Chapter 8A provides that if 70% of the occupiers decide to acquire the property, then they have to pay 100 times the rent of the property, monthly rent, not even yearly rent, pay 100 times the rent, and you become the owner of the property. And it's occupier, not even tenants. And we'll, of course, make our submissions on that. Now, if I succeed on the rent control, and the rent is invalid, then possibly my challenge to 8A becomes much easier. On 8A also, I'll of course independently make my submission. Now, my lords, this matter comes through before your lords 9-judge bench combination by 4 reference order. First, 2 judges referred it to 3, 3 to 5, 5 to 7, and 7 to 9. So may I just very quickly indicate, before briefly indicating the facts, the 3 reference orders. First one gives no reason, so I'm not taking my lords to that. The first one from 3 to 5 is 1st May 1996. And if my lords has volume 5 of the convenience compilation, it starts at page 2787.
Volume 5, page 278, sir.
Lordship.
Nineteen 1996.
4 SCC, page 49.
So the volume 5, page 278, sir.
Lordship. My lords, as paragraph 1 on the next page. One of the main questions for decision in these matters pertains to the constitutional validity of Chapter 8A, inserted in 1986 in Maharashtra Housing Area Development Act. We all call it MADA, my lords. Hereafter referred to as MADA Act, providing for acquisition of certain properties on payment of 100 times the monthly rent for the premises. These properties are mainly buildings which were first let out prior to the year 1940 on monthly rent, which the owner claimed is a measly amount of current value of property in Bombay and the present value of the rupee. Section 1A was inserted in the MADA Act in 86, and it contains a declaration that this act is for giving effect to the policy of the state towards securing principles specified in Clause B of Article 39 of the Constitution of India. Article 31C of the Constitution is therefore retracted for excluding the attack to the validity of the enactment on the ground of Article 14 or 19 of the Constitution. My lord, if I may just give a few comments while reading this. 21 is not protected under this. Similarly, 300A is also not protected. So we will be making submissions on that. And also 31C, my lords, now in Kesare in matter is laid down that the reasons must be given to the president, because that presidential approval is required for two reasons. One is because there is a conflict between a central law and the state law. In fact, three laws in this case, including Transfer of Property Act. So you must indicate to the president why you are seeking consent. And if that indication is not there, that presidential consent is not valid, in this case, no material has been produced, and we'll be making that point. My lords. Para 2. In order to circumvent the effect of Article 31C of the Constitution, Nariman, the learned counsel for the petitioner, contended inter alia that 31C does not survive because of the events subsequent to the decision in Keshwananda Bharti. Shri Desai, the learned counsel for the respondent, replied to those arguments by contending that 31C as originally enacted minus the latter part, which was declared to be unconstitutional in Keshwananda Bharti as it upheld in Minerva Mills, excluded any attack on the constitutional validity of the enactment. Both the learned counsel had submitted synopsis of their rival contention in the form of written submission. A brief history of Article 31C would help to appreciate the rival contentions. Article 31C as originally enacted was inserted in the Constitution with effect from 20th April to 1972 by Section 3 of the Constitution, 25th Amendment Act 1971. The constitutional validity of Article 31C was examined in Keshwananda Bharti, which was decided on 24/4/1973. At page 1001 of SCR, the conclusion of the majority opinion are summarized, wherein conclusion number 5 is the second part of Article 31C, namely, and no law containing a declaration that it is for giving effect to such policy shall be called in question in any court on the ground that it does not give effect to such policy was declared to be invalid, while the rest of Article 31C was upheld as valid. Thereafter, with effect from 3/1/1977 by the Constitution 42nd Amendment Act, Section 4, the word the principle specified in Clause B and C of 39, the words all or any of the principle laid down in Article 4 were substituted. Then on 15/5/1978 was introduced in Parliament, wherein Clause 8 was to amend Article 31C to restore it to the position prior to the amendment by the Constitution 42nd Amendment, in the form as it stood as a result of the decision in Keshwananda Bharti. However, Clause 8 of the bill was dropped after debate in Parliament, and this attempt of the Parliament was abortive. Then came the decision in Minerva Mills. The operative part of the order in Minerva Mills was pronounced on 9/5/1980, and the reason for the same were pronounced on 31/7/80. The basis of which decision in respect of 31C was rendered in Minerva Mills as is indicated in para 24. The next question which we have to consider is whether the amendment made by section 4 of 42, amendment to article 37(1) of the Constitution is valid. Mr. Palkiwala did not challenge the validity of the unamended article 31C, and indeed that could not be done. The amended Article 31C forms the subject matter of a separate proceeding, and we have indicated therein that it is constitutionally valid to the extent it was upheld in Keshwananda Bharti. In Minerva Mills, Section 4 of the Constitution 42nd Amendment Act was held to be invalid, and decision was rendered on the basis that 31C continued in the form in which it existed as a result of the decision of Keshwananda Bharti. The next decision in Vaman Rao, wherein the operative order was pronounced on 9/5/1980, and the reasons were pronounced on 13 November 80. These are reported in 1980 so and so. In Vaman Rao, also Minerva Mills, it was assumed that 31C as it stood prior to its amendment by the Constitution 42nd Amendment as a result of the decision Keshwananda Bharti stood revived. The decision in Sanjeev Cook, versus Bharat Cooking Coal. Even though in Sanjeev Coke there is criticism of the majority opinion in Minerva Mills, an expression of broad agreement with the view of Bhagwati J as he then was, in that decision, the judgment proceeds on the basis that 31C stood revived. If I may turn to the next paragraph and come to just the last 2-3 lines, if my lords permit, or should let me just read the whole paragraph. One of the submission of Sri Nariman is that the doctrine of revival, as it applies to ordinary statute, has not been applied in India to constitutional amendments. On this basis, he contended that clause 8 of the bill, 88 of 78, which was to revive 31C as it stood as a result of Keshwananda Bharti, having been dropped in Parliament, 31C as it stood as a result of Keshwananda Bharti, did not stand revived when the amendment was made to the Constitution 42nd Amendment 1976, with effect from 3rd January 77, was later struck down. He contended that the decision in Minerva Mills proceeded on the basis of a concession made by Mr. Palkiwala and on an assumption that 31C as it survived as a result of Keshwananda Bharti stood revived after subsequent events. He submitted that that is not the decision in Minerva Mills, since the question neither arose nor was it the decision therein, and decision in Vaman Rao and Sanjeev Coke also proceeded on the same basis. He contended that 31C does not therefore survive in the Constitution, and benefit thereof is not available to exclude the attack to the validity of MADA Act on the ground of 14 and 19 of the Constitution. Several other arguments were advanced by Shri Nariman related to his contention. Mr. Nariman also referred to the word Constitution shall stand amended in accordance with terms of the Bill 368(2) to support this contention. Shri Nariman also contended with reference to certain decision that such a question relating to a provision in the Constitution cannot be bypassed on the principle of stare decisis. Shri Ashok Desai, on the other hand, contended that the matter stand concluded by the decisions of Minerva Mills, Vaman Rao, and Sanjeev Coke, wherein the revival of 31C as it stood as a result of Keshwananda Bharti was not even disputed, because that is obvious position in law. He also contended that there is nothing in 368(2) to support the contention of Shri Nariman. Shri Desai also submitted that it is too late to consider this question when this is how 31C has been understood for years. The details of the arguments of both learned counsels in the form of synopses of written submissions are on record. The question is whether these points which have been raised by Shri Nariman should be considered and decided by a larger bench of at least 5 judges. Shri Desai submitted that since these contentions have no substance merely because related to interpretation of certain provisions of the Constitution, is no ground to require hearing of the matter by a bench not less than 5 judges. Having heard learned counsels for some time, we have formed the opinion that it would be more appropriate for a bench of not less than 5 judges to consider and decide these questions for an authoritative pronouncement on the same. The decision in Minerva Mills, Vaman Rao, and Sanjeev Coke are all by a bench of 5 judges. The question in the form it is raised by Shri Nariman did not arise for consideration in any of those decisions, which were rendered on certain premises as indicated therein, which assumption is now seriously challenged by Shri Nariman. Even it is assumed that Article 145(3) of the Constitution is not attractive, it does appear to us that in order to settle the controversy on this point, which is of some significance, and to avoid the questions being re-agitated before another bench of less than 5 judges, the more appropriate course is to refer the matter for being heard and decided by a bench not less than 5 judges. For the aforesaid reason, we direct the papers be laid before the learned Chief Justice for constituting a larger bench of not less than 5 judges. Now, my lords, this is the first reference, and then the matter did come up before 5 judges, and that is now reported at page 3150 of volume 5 as 2001, 4 SCC,
2001.
4 SCC, page 455,
Get it in volume 5A.
3150. Again, a short order of 2 pages. I can just quickly read them. Again, the background is given. Lodge. My Lords has volume 5, page 3151,
Just a second.
para 1.
3151, right?
Lordship.
got it.
Starts at 3150 at 3151. Lordship. In these cases, the main challenge is to the constitutional validity of Chapter 8A, which was inserted in 1986 in the MADA Act in 1976, which inter alia provided for the acquisition of certain properties on payment of 100 times the monthly rent for the premises. By the said amendment, Section 1A was also inserted in the Act and contains a declaration that Act is for giving effect to the policy of the state towards securing the principles specified in Clause B of Article 39 of the Constitution of India. In view of Article 31C of the Constitution, the contention of the state was that the validity of any part of the statute on the ground that it violated Article 14 or 19 of the Constitution was not permissible. The case was heard by a bench of 3 judges. At that time, on behalf of the appellant, a contention was sought to be raised inter alia to the effect that 31C did not survive because of the events subsequent to decision in Keshwananda Bharti case. It was also submitted before the bench that the doctrine of revival as it applied to ordinary statutes did not apply to the constitutional amendment, and when a part of the 42nd Amendment which amended 31C had been held to be invalid, it did not result in the automatic revival of the unamended 31C. In view of the aforesaid contention which was raised by the order of 1596 reported in so-and-so, the matter was referred to a larger bench of not less than 5 judges. We heard the counsel and led on various issues which arise in these cases. One of the points which arises for consideration relates to interpretation of 39B of the Constitution. In state of Karnataka versus Ranganath Reddy, validity of the Karnataka Contract Carriage Acquisition Act 76 was challenged, and the question which arose was whether the state government could acquire and then transfer countersigned portion of the interstate permits to Road Transport Corporation. 2 judgments were delivered. In that case, Justice Krishna Iyer J. for himself and 2 other learned judges, while concurring with the decision in Utwalia J, with whom 3 other judges agreed, interpreted 39B of the Constitution and then came to the conclusion that the Act had direct nexus with 39B, and by virtue of Article 31C, its validity could not be challenged on the ground of it being violative of Article 14, 19(1)(f) of the Constitution. Utwalia J in this judgment observed that we do not consider necessary to express any opinion with reference to Article 31C read with Clause B and C of Article 39 of the Constitution. Our learned brother Krishna Iyer J has prepared a separate judgment specially dealing with this point. We must not be understood to agree with all that he has said in his judgment in this regard. The need to interpret 39B again arose in Sanjeev Coke versus Bharat Coking Coal. While upholding the validity of coking coal mines, Nationalization Act 1972, the 2 other connected enactments, the Constitution bench adopted the interpretation of Article 39B as enunciated by Krishna Iyer J in the Ranganath Reddy case. This interpretation has also been followed by a division bench of this court in state of Maharashtra versus Basantibai Mohanlal Khetan. The interpretation put on Article 39B by Krishna Iyer J in Ranganath Reddy case was not specifically assented to in the majority decision, but in Sanjeev Coke it is observation in the judgment of Krishna Iyer J which has been followed. Having heard the counsel's at length, we are of the opinion that the views expressed in Sanjeev Coke case requires reconsideration, keeping in view the importance of the point in issue, namely the interpretation of 39B. It will be appropriate if these cases are heard by a larger bench of not less than 7 judges. The papers.
Now it's very clear. Ranganath Reddy, the occasion for a reference to 9 judges arises because Ranganath Reddy was a decision of a bench of 7 judges. You had the majority judgment of Justice Untwalia concurred in with on behalf of 3 other judges, that makes it 4. And Justice Krishna Iyer concurred in with by 2, that makes it 3. The majority judgment says that there are certain issues which have been dwelt with on by Justice Krishna Iyer on the interpretation of 39B and C. We should not be read as having accepted his interpretation. Justice Krishna had specifically held that material resources of the community will also include private property.
Lordship.
Right? So 4 judges said we are not expressing any view on what has been held by Justice Krishna.
Correct.
Therefore, the occasion for a reference to 9
Correct.
arose because clearly the views in Sanjeev Coke, which follows Ranganath Reddy,
Correct.
is something that this bench of 5 judges doesn't agree with.
Correct.
But they had to refer it to 9 for the reason that Ranganath Reddy
Or 7.
is 7.
Lordship.
And in Ranganath Reddy, though it's a view of the minority on the
Lordship.
interpretation of 39B,
Lordship.
that is something that has been followed in Sanjeev Ko.
Absolutely.
So if you look at this now, it's very
Correct.
clear
Lordship.
that the ambit of the reference to 9 judges is squarely only on the content of 39B.
Lordship. So, Lordship is
31C.
right, but there is something more that happens which I'll just
Whether
indicate.
31C continues to subsist or not,
Lordship.
or whether it has been revived, is not
Lordship.
something which has been referred to us at all.
Lordship, I'll indicate there's one more reference order, and I'll just indicate it also refers to IR Coehlo, which was then pending before 9
Let's
judges.
see that.
I'll just indicate, my lord. So my lords may have the final. So this one is laid before 7 judges. And my lord recalls that time the understanding was that you could only refer it to the next larger bench. But my lords may now come to 2013 7 SCC 522, which is the final reference order, which is in volume 5, page 3409.
By 7 judges?
Lordships, 2013, volume 7 SCC 522,
2013.
volume 7 SCC 522. At volume 5, page 3409 PDF.
09.
Lordship. My lord. My lord, may I just start first? Bench of 5 learned judges is referred to 7. Put shortly, the question is as to the interpretation of 39B of the Constitution, which speaks of the distribution for the public goods of ownership and control of material resources of the community. In state of Karnataka versus Ranganath Reddy, 2 judgments were delivered. In the judgment delivered by Krishna R.J., speaking for himself and 2 other judges, the view was taken that material resources of the community covered all resources, natural and man-made, publicly and privately owned. The other judgment delivered by Utwalia J. on behalf of himself and 3 other judges did not consider it necessary to express any opinion with regard to 39B. It was, however, made clear in this majority judgment that the learned judge did not subscribe to the view taken in respect of 39B of Krishna R.J. The view taken by Krishna R.J. in Ranganath Reddy was affirmed by a constitution bench in Sanjeev Coke. Now, in the course of the arguments before us, the learned Solicitor General for Union of India and the state of Maharashtra has drawn our attention to the judgment of a bench of 9 learned judges in Mafatlal. Speaking for himself and 4 other judges, Jeevan Reddy J. said that material resources of the community are not confined to public resources, but include all resources, natural and man-made, public and private, owned, is repeatedly affirmed by this court. Now, my lords, of course, we'll make our detailed submission, but this issue never arose in Mafatlal, where the question was of unjust enrichment, whether taxes, if they are held to be void, how do you return the term? Lordship. So,
Question of refund.
Lordship, absolutely. So 39B did not arise at all.
5 read with 39.
Paid or not on that.
Lordship. So this issue never arose. These were just observations, and we will be submitting this was obiter, but be that as may I continue. And reference was made to the case of Ranganath Reddy, Sanjeev Coke, and state of Tamil Nadu, L. Abu Kavur Bai. Having given due consideration, we are of the opinion that this interpretation of Article 39B requires to be reconsidered by a bench of 9 learned judges. We have some difficulty in sharing the broad view that material resources of the community under 39B covers what is privately owned. Now, my lords, next paragraph is important. Given that there is some similarity in the issue here involved and in IR Coehlo versus state of Tamil Nadu, which already stands referred to a larger bench, preferably of 9 judges, we are of the view that these matters should be heard by a bench of 9 learned judges immediately following the hearing IR Coehlo. Now, I have to indicate this. Coehlo has nothing to do with 39B. The issue there was, even though it's been put in the 9th schedule, are 14, 19, and 21 available to the extent they affect the basic structure. And there are observations there which my lords may consider in this matter also on 31C also, which says even though you put it in the 9th schedule, the trinity of rights under 14, 19, 21 can still be taken for the purposes of challenging a particular law, a specific law. So there, of course, there was a constitutional amendment to add it to the 9th schedule. Here, despite 31C has no such provision, there are observations in Coehlo which says that I can still challenge, and therefore we'll be pressing that point also. That despite the fact, even if my lords holds that 31C survives, that it's protected by 39B, my right to challenge under the trinity of 14, 19, 21 still survives, which is what Coehlo has said. So we'll make that good.
Deshwananda Bharati.
Lordship.
Deshwananda Bharati, they affirmed whatever was there prior to the judgment of.
Lordship.
Incidentally, it is tomorrow, 24th of April, 73. But anything thereafter has to meet the challenge.
Absolutely, I'm grateful. But therefore, my lords have thereafter held that even acts and statutes, not just constitutional amendment, cannot be violative of the basic structure, and point out there are two direct judgments that even acts on the standalone basis can be challenged on the ground that they violate the basic structure. And Coehlo, now 9 judges of my lord's court, have upheld the same. Now, there are observations that 31C also this will apply in Coehlo itself, but that issue did not squarely arise here, there.
But if you now look at the last two orders which you have shown us,
Lordship.
the 7-judge
Lordship.
and then of 5,
Lordship.
the two orders really dwell on 39B.
Lordship.
There is really no reference to 31C.
Lordship.
Or nor is that point specifically referred to the bench of
Except in para 6, insofar as they say await Coehlo. So Coehlo would then be that are those rights available?
Because they probably wanted to await Coehlo because another 9-judge.
Coehlo must have been, my lord, on the anvil of being listed.
If it has some impact.
On the anvil of being listed. That appears to be.
No, I was also appearing in Coehlo. It was not on the anvil of being listed. But we pointed out that the same issue arises there in the context of 31B. That even if you put that act in the 9th schedule, you can still challenge it on the ground of violation of the basic structure. And that's the issue we raise here also, that even if it's protected by 31C and we fail in all our other contention, it is still open, and that's the short issue we want your lordships to consider.
So why does a bench of 9 have to consider that issue?
Because, in fact, the Coehlo reference order explains that, but Coehlo as 9-judge bench decided this issue for 31B. So we'll indicate, my lords, as we
Very tenuous like that.
it is to that limited extent, yes. But my lords, we are, just give me a moment.
Correct. I mean, that is the point that I.
Three ways we also discussed that. May I just so lordships, I'll just submit there are 2-3 possibilities. I'm not. Lordship, so I may just, this is what we consider, my lords. I'll just place it before you, and then you may consider as you, my lords, may.
It's not the ambit of the reference.
Lordships, I'll do that. But we thought there were three possibilities that arise in this case.
Yes.
The two judgments, Sanjeev Kok and Abu Kaur Bhai, are 5 judges. Ranganath is 7 judges. But Minerva, the Mafatlal judgment is 9 honorable judges. Now, if my lords either can hold that Mafatlal is obiter, then it's open to my lords to decide this issue. Otherwise, my lords may have to consider whether it has to go higher to a 11-judge bench in case my lodge is not in, doesn't hold that Mafatlal was arbiter and it's clearly arbiter, we'll try to make that good. In which case it's open to my lodge to decide this matter is our first submission. Will consider whether on Mafatlal issue, my lodge wants to consider that and will make it good that those were arbiter observation. It has nothing to do with the issue at hand. Or it should go higher. That's one issue that my lodge will decide. On 39 BNC, my lodge, we are with my lodge that if 39 BNC is decided, it can go back to 5 judges for consideration on 31C, whether it survives or not. But we would like to make our submissions on Coehlo because Coehlo specifically deals with the scope of challenge under 31B and C. Although 31B arose there, we do want to make our submission that the same principle will squarely apply for 31C. Because if it does, then my challenges under 14, 19, 21 are still available even for these laws, even if protected under 31C.
You can also argue that before
we can. Lordships, we can.
3 judges or 5 judges.
I will not disagree. My lodge is right. So, but we like to place Coehlo, and then my lodge may take a view on my lodge.
So now, how do you want to begin?
No, my lodge. So I have we've drafted some propositions. I'll briefly indicate what all arises. Not all of this has to be decided by my lodge, but we'll just place what we wish to argue. Seeing those issues, and then if my lodge permits, I'm proposing to read the Malpe judgment and then hand it to my colleague, Mr. Anjarujina. So these are the two aspects. So may I just indicate these are the issues that we feel arise. Most of them, of course, will not be have to be considered by this bench, but I wanted to place these on before my lodge. The first is whether Article 31C of the Constitution of India survives after the judgment of this Honorable Court in Minerva Mills in so and so, striking down Section 4 of the 42nd Amendment Act. Now, whether Chapter 8A of MADA has received the assent of the President of India as required under the provision of 31C and as decided by the judgment of this Honorable Court in Kesre, that is, reasons were given, etc., and they did not produce that. Whether the onus of proving that the assent of the President was in compliance with Kesre is on the state and whether they have discharged the burden. That again squarely arises from the pleading, but we'll make submissions on that. Now, whether the material expression material resource of the community occurring in 39B of the Constitution would include private properties, and whether Chapter 8A of MADA subserves the purpose of 39B and is for public good. So one, because 39B has two parts, material resources for public good. So we are submitting on both. Now, whether Chapter 8A of MADA and Maharashtra Rent Act can be challenged under Article 14, 19 and 21 of the Constitution of India in light of IR Coehlo versus State of Tamil Nadu, even if Article 31C survives. Then 7, whether MADA and Maharashtra Rent Act are invalid, being contrary to 21 of the Constitution of India. Now on that we are again, I'm just indicating the point, 21 is not protected, 31C is only for 14, 19. 21 is right to life, and there are reports of the respondents themselves, their committees, which say that there are a lot of landlords who are poor. Not all landlords are rich and not all tenants are poor. A lot of landlords have put in their hard-earned income in building a house, and they're not even able to survive. All their reports, we place them on record, is what we'll be arguing.
Drive down Marine Drive, right, in Mumbai.
Lordship.
And you see all those buildings, the Art Deco buildings. They're most of them are tenanted.
Lordships. All of them, in fact.
All of them.
All of them, in fact. My lords, all. The rent of most of those apartments do not exceed 200 rupees, even today. That's it. In fact, initially they were all under 80 rupees, the Act itself notes. And now they've gone up a little bit because of taxes, etc.
Property is relatable to the annual letting value.
No. There's some amount of compensation they allowed us, that's all, out of the taxes. But we are bearing the tax also, which they are not paying. The tenants are not even paying the tax that has gone up from time to time. And again, their report says that we are paying out of pocket. Most of us are in the negative.
Issue 4, 15 and 16.
Lordship.
4 you have said.
Lordship.
Whether the expression material resource of the community occurring in 39B
Lordship.
would include private property.
Lordship.
15, whether the observations in para 86 of Mafatlal is obiter dictum and not binding.
Lordship.
And 16, whether the judgment in Sanjeev Cove could have upheld the certain observations made in the concurring view, that is, you are referring to Ranganath Reddy,
Lordship.
about Article 39B of the Constitution,
Lordship.
with which the majority opinion expressly did not agree in state of Karnataka versus Ranganath Reddy.
Lordship. Lordships, we have no difficulty, but we like to place Coehlo judgment before my lords takes a final view. That's all I'm saying.
What else, Mr.
Lordship, may I just indicate what are the other issues very quickly? 8 and 9 relate to Article 300A. This is also a development after the last referent order. In clay tea plantation now, if you take acquire property, it must be for public purposes, and the compensation cannot be illusory. So on this ground also we are submitting that we are entitled to succeed. So may I skip that. 11 is again the Coehlo point that I can challenge under. Then 12, whether Maharashtra Rent Act is on the face of this Honorable Court judgment in Malpe Vishwanath void and is liable to be struck down. That's the argument that if the standard rent provisions go because of the prospective judgment, then MADA itself will go in as a consequence. Then whether Maharashtra Rent Act, that's the writ petition 660, again can go to a smaller bench. Whether Maharashtra Rent Act takes away the basis of Malpe Vishwanath Acharya. Then 14 is void, chapter 8A. Then my lords has already seen 15, 16. Then 17, whether chapter 8A of MADA can at all be treated as a law of public good or in the nature of land reform, or are per se illegal and violative of the basic structure of the Constitution of India as it purports to transfer property from one private person to another private person. Then whether there is any evidence to show that all landlords are wealthy and tenants are all poor. Then whether in view of report of 12th Law Commission finding that not all landlords, again it's a factual, whether the property is purchased through hard work of property owners and or their predecessors can be treated as estates like Jagirdari, Inamdari, Zamindari system which can be redistributed. Then whether chapter 8A was enacted merely as a misconceived attempt to deal with their own wrongs including inter alia freezing of rents, failure to build adequate housing, as also prevent disabling the landlord from maintaining the tenanted premises while failing to maintain the same themselves. So, my lord, these are not all the issues we are submitting before my lord. My lords, with that, I'll only point out one judgment, which is the Malpe judgment, where my lords has already dealt with the Rent Act, and then I'll request Mr. Andhyarujan to take over on 31. No, you're taking 31C, right? Sorry, Lordship. Now, my lords may just have
Arguing 39B though.
Mr. Devarajan.
Malpe judgment is only on Rent Act and its validity. Your lordship's not even, not concerned.
I'll-
not be convenient if we begin with the argument on 39B.
Lordship, we can do. Lordship, we can do that.
Of course, we'll not prevent anyone to argue the other 31C
No difficulty.
argument also.
No difficulty. Then would my lords want, I was only pointing out Malpe for a few facts. I can just point out those dates and then that's all I want to do. A few dates so that the rest of the submissions will make more sense in light of that.
About the relevance of Malpe, all right, what some dates
No,
you want to give us?
just dates, a few dates I'll point out.
Okay, just give us those dates. We just at least take them down so that we.
Lordship, they're not more than 8-10 dates, so I'll just indicate. So this whole process started on 19/6/1939, when the Bombay Rent Reservation Act froze the rent with effect from 1/1/1939.
1939, what happened?
19/6/1939, the Bombay Rent Reservation Act came. Rent Restriction Act came. This is the first law which froze the rent as on 1/1/1939.
Froze the rent as of?
1st January 1939. Then there is the first Bombay Rent Act came on 12th May 1944, which is the full name is Bombay Rent, Hotel Rates and Lodging Houses Rates Control Act. Then 13th February 1948 is the Rent Act, which was then considered in Malpe judgment.
Bombay Rent Act was 12th May 1944, right?
12th May 1944 and then 13th February 1948. It was replaced by a new law. So we are concerned with 13th February 1948. Then my lord, MADA came again twice. 5th December 1977 was the predecessor MADA Act. And then the one we are concerned with is 27th April 1986, which has Chapter 8A, which we are concerned with. Now, I'll only then give the date of the judgments. Then the judgment in Malpe Vishwanath Acharya is 19th December 1997. My lords, the last date is 1st April 1998 is the Maharashtra Rent Act. My lords,
Judgment is on?
Malpe is 19th December 1997. And 1st April 1998 is the Maharashtra Rent Act. Just to give the broad dates so that. Grateful, man.
Thank you, Mr.
Thank you.
So, Parik, the last date, Maharashtra Rent Act is?
1st April 1st April 1998, with effect from 1st April 1998. In fact, after Malpe came, they came out with notification, extended it twice. We filed this writ petition, then they brought the Maharashtra Act, and then they amended the writ petition.
So the 1988 judgment is with regard to which Rent Act of Maharashtra?
Maharashtra Rent Act of 1948, right? 1948. 1948. Large.
You mean Malpe? Is it?
Malpe.
Malpe is about the
1948. Large. take it there, I will come back. Bombay Rent Act is 47, not
47,
40.
not
47. Lodge.
This Bombay Rents and Hotel
1940.
Lodging House rates
Lodge.
to lakh 47.
Lodge. I'm grateful.
Thank you, Mr. Parekh.
No, no, it's yours.
Yes, Mr. Parekh.
Lord, I have noted everything that your lordships have said. Lord, on 31C, my Lord, I just wanted to say a few words with regard to Coehlo, if your lordships permit. Lord, before your lordships take a decision on the reference, my Lord. Lord, of course, my Lord, whether your lordships decide to hear it now or whether your lordships refer it down, Lord, it will then go to a constitutional bench of 5 judges. Lord, is a matter for your lordships to entirely decide. Lord, your lordships have seen the reference, so Lord, I'm not going to read them again. And your lordships is of course right, is that the first reference from 3 to 5, Lord, notice the 31C issue, Lord, what I'm calling the dead letter issue about whether it has revived or whether it required validation. Lord, in the subsequent reference, in one sense, that was noted but not mentioned again. And undoubtedly, the reference to your lordships today arises out of the last order. Now, my Lord, it's a matter of construction about how your lordships read that last order. And I quite appreciate, my Lord, the Chief Justice's point that actually the reference is on the Mafatlal judgment and the 39B point. But, my Lord, I wanted for your lordships to consider this. I'm not sure that, Lord, it has become clear in the order what exactly the significance of Coehlo is. Lord, I'm fully aware of the fact that your lordships are fully seized of Coehlo. But Lord, if your lordships will hear me on that for 2 or 3 minutes, because
Coehlo, right?
Coehlo only.
Certainly.
Lord, because I believe, Lord, it has a very significant bearing on 31C and on the facts of this case. No, but I'll just summarize it first for your lordship.
Certainly.
Lord, Coehlo itself was a case which was referred to 9 judges. Lord, it was referred to 9 judges, and I will show your Lordship the reference. Lord, as a result of inconsistencies which were noted in the judgments of Vaman Rao between the then Chief Justice, Justice Chandrachud, and Justice Bhagwati's judgment, and also the judgment in Minerva Mills and Vaman Rao. I'll show your Lordship that. Justice Bharucha as he was then, Chief Justice Bharucha as he was then, Lord, therefore referred the matter up. Lord, the question that was framed before the 9 judges in Coehlo was with reference to 31B. Lord, it concerned a Tamil Nadu Act for acquisition of land. Lord, the Gudulur Janmam Acts, so on and so forth. Lord, the question was framed on 2 bases. Lord, one is the question with regard to whether 31B is valid. And the second was a question with regard to fundamental rights and with regard to the scope of fundamental rights, and in particular, Article 14, 19, and 21 of whether they are included in the basic structure. Now, my Lord, as your Lordships know, my Lord, Keshav Nanda, my Lord, has been a decision which has been constantly evolving by a process of interpretation from time to time. Lord, although, Lord, the majority in Minerva Mills came very, very close to saying that 14 and 19 are a part of the basic structure, they didn't say so in terms. Lord, they went on then to strike down the amended portion of 31C and upheld it the unamended portion of 31C. Lord, this question has now been squarely addressed, Lord, in the Coehlo judgment. Lord, I'll come straight to the point, Lord. The Coehlo judgment now entrenches, well, there's a little bit of controversy, I'll come to that in a bit, but entrenches 14, 19, and 21 as part of the basic structure. Now, Lord, first to put the point a little simplistically, Lord, your Lordships are fully aware of 31C. Lord, 31C is the safe harbor provision. Lord, in the event that 39B and C stand attracted, then there can be no challenge on the ground of 14 and 19. The Lordships are also aware that originally there was 14, 19, and 31. Lord, when the right to property got deleted, Lord, that was also consequently deleted. Now, Lord, if 14 has been held now to be a part of the basic structure, the real question that arises in my respectful submission to your Lordship is how effective the validity of Article 31C ruled upon in Keshav Nanda Bharti remains. And Lord, I'll just tell your Lordship why I say this, Lord. But as your Lordships are aware, Lord, in Keshav Nanda Bharti, Lord, 31C, the latter part was struck down, the declaratory part. The first part was, however, upheld. Lord, it was upheld, Lord, like everything about Keshav Nanda Bharti, Lord, in a fascinating way. Lord, 6 of the judges who believed in the unlimited power of the Constitution to amend, Lord, upheld it. Justice Khanna upheld it on a slightly different basis, drawing a parallel with 31A. Although, as we all know, that Justice Khanna, in fact, believed in the implied limitation and the basic structure theory. Lord, that was interpreted, Lord, in Minerva Mills. It was read through in Vaman Rao, as I'll show your Lordship. And, my Lord, we are now presented with the effect of the Coehlo judgment. Because, my Lord, the language of 31C, and your Lordship will just see the wide language, Lord, it brooks no interference with 14 and 19 rights. So, Lord, and there's a lot to be said, my Lord, with regard to how you will.
Let's read the statute.
Would your Lordship mind, my Lord? Lord, if your Lordship will come to 31C.
Statute, the provision. Yes.
My Lord, I have prepared a short note on Coehlo also. I'll just come to that in a bit. 31C, saving of laws giving effect to certain directive principles. Notwithstanding anything contained in Article 13, no law giving effect to the policy of state towards securing. Now, my Lord, this is the portion which was struck down in Minerva Mills, all or any of the principles laid down in 39(4). Therefore, your Lordship will read it in the old language, which says in relation to 39B and
37 in our book.
Yes, your Lordship is perfectly correct.
The principles specified in clause B or clause C of Article 39.
Perfect, my Lord. So that is, my Lord, my revival argument.
Shall be deemed to be void.
Shall be deemed to be void on the ground that. Now, my Lord, please note the sweep of this, my Lord, that it is inconsistent with or takes away or abridges any of the rights conferred by Article 14 and 19. Well, the latter italicized portion is the portion which was struck down in Keshav Nanda Bharti. So, my lord, today, my lord, with the Coehlo judgment, my lord, it is very difficult to understand what force remains in Article 31C. 31C undoubtedly valid as rule.
Then, Mr. Andhyarishna, if you argue that, you are virtually then asking for a reconsideration of the correctness of Keshwan.
No, Lord, I'm conscious.
Do that.
No, I'm fully conscious of that. Lord, that's an outrageous argument, and my lord, and my lord, so Lord, yes, my lord, the logical extension of the Coehlo argument may take us to Keshav Nanda Bharti. That is true, but your lordships are presented with a 31C problem. I have some solutions to that, my lord. If the occasion arises, my lord, I will argue that.
Coehlo was essentially with 31.
Because my lord, what meaning is left in 31C if we say that every aspect of 14 can be used as a challenge?
But we are a bench of 9. We are bound by the principles which have been laid down in Keshwan and Bharati, which upholds 31C as it was originally enacted.
Correct, sir.
And as originally enacted, 31C gave, as you rightly said, it's a safe harbor provision in respect of a challenge to the laws giving effect to the directive principle contained in 39B and C on the ground that it violates Article 14 and 19 of the Constitution. Now, that has been upheld by a larger bench of 13, by a bench of 13.
By a bench of 13 judges.
For us, that's now a dictum. I mean, that's a given, that 31C is valid.
I accept that.
Right? And therefore, there's no reason for us to go into the impact of Coehlo on the correctness of the decision on Keshwan and Bharati.
So, my lord, that is a very far-reaching proposition. Your lordships are right. And my lord, against that suggestion, Lord, if at all I made it, my lord, is of course the Minerva Mills dicta, my lord, where actually they said that whatever be the case.
These walls are witness to what happened after Keshwanan, when a review was assembled in this very court, and then abruptly it was discharged. We'll not forget that history of our court. We'll now allow Keshwan to rest where it is.
No, long may it rest in peace, my lord, undoubtedly. My lord, so, my lord,
not just rest in peace, but as a vibrant part of our discourse, isn't it, as it is today? Because once we open up the canvas, there'll be.
When we say that 6 judges are right.
Continue to guide us.
No, my lord, I don't say that. But just bear with me for a minute, my lord.
Guide us.
No, my lord, so the Minerva.
With 31C in its original form, as upheld in Keshwan, we'll of course we'll see Coehlo for 5 minutes with you, no difficulty.
No.
We'll treat 31C as upheld in its original form by Keshwan and Bharati to be the position which binds a bench of 9 judges, and then we accept it,
Lord, accept it, my lord. But may I just point out to your lordship, my lord, that Coehlo presents a problem for your lordship, my lord, in this case, in this sense. Lord, what are we to do with Coehlo if we accept the validity of Article 31C? Because, I mean, my lord, your lordship sees that it is quite obvious that 31C is now effectively emasculated as far as it comes up against 14 and 19. But 14 and 19 challenge now in view of the Coehlo judgment is a basic structure challenge. Lord, assume that 31C was brought in for the first time by an amendment today. Lord, it would be beyond the amending power of the Constitution. And being beyond the amending power of the Constitution would be void. Now, Lord, I quite appreciate everything that your lordship has said, but it is a very serious issue which arises, Lord, in the context of 31C. Now, Lord, I show your lordship Coehlo. But Coehlo was a judgment actually under 31B. What the question framed in paragraph 5 was under 31. Correct. 9 schedule question. Lord, they don't actually strike down 31B. In fact, what Coehlo veers towards is an exposition on fundamental rights. And there are some questions that arise, but one thing it does is that it entrenches these three, Lord, 14, 19, 21.
Those laws which were inserted in the 9th schedule as of the date of the judgment in Keshwan Bharati are immune.
Yes, your lordship is right.
Those laws which were inserted in the 9th schedule after the 24th of April 1973 would be still amenable to a challenge under...
But which is exactly, if your lordship recalls, what the majority also said in Minerva Mills. Which is what...
In Vaman Rao, it was sustained, this view.
Minerva Mills, I'll show your lordship, Vaman Rao and Minerva Mills, both. Now, my lord, the point that I leave your lordship with, and the point for consideration was,
You know, really speaking, why should a bench of 9 go into these issues at all? You know, the first thing you ask yourself is, why 9? What is the occasion for 9 and not 7? And the occasion for why 9, why not 7, why not 5, why not 3? Actually, you know, the reason for the constitution of a 9-judge bench is obviously because there's something operating in a 7-judge bench, which is a matter of concern. Now, actually, in this case, Ranganath Reddy, the bench of 7, has not said that 39B will include resources of a private nature, right?
Majority.
In fact, it's quite to the contrary. Justice
Chip is right.
Upadhyay specifically in his majority opinion keeps that issue open, saying that we are not
agreeable with.
We shouldn't be construed to have agreed with Justice Krishna's viewpoint.
My lord.
The problem, yes, there's a specific paragraph on that.
Yes, my lord.
Now, the problem arose because Sanjeev Koch lifted Justice Krishna's perception on the interpretation of Article 39B and made it a bench of 5. Now, it could have been resolved by 7 also. It could have been resolved by 7 by saying that, look, what was done in Sanjeev Koch was plainly incorrect because it overlooks that the view of Justice Krishna was a view of a minority on that subject, or at least a plurality and not a majority in Ranganath Reddy. But the 7 judges thought that we should refer it to 9 only because in the meantime Mafatlal has come. And Mafatlal has that observation in para 86. Now, if we come to the conclusion that, look, that observation in Mafatlal is obiter, because Mafatlal was really dealing with unjust enrichment. There's an observation that would end the issue on Mafatlal, 1. 2, if we then construe the judgment in Sanjeev Koch to the extent of interpreting Ranganath Reddy, we'll say that the bench in Ranganath Reddy, the 7-judge bench, has not laid down this principle at all as a principle of constitutional law. Of course, we are a bench of 9. We can still look at the interpretation of 39B, whether it will apply cover private property as well. And you may argue that 39B should not cover material resources of the community cannot mean material resources of a private person. That is something which you can certainly argue before us.
My lord, I leave it up to your lordship, my lord. As I said, it is your lordship's reference.
31C argument here, you know, we'll, of course, we're 45 minutes short of lunch. We'll all have a conversation between ourselves.
But in the meantime, yes, my lord, I fully appreciate what your lordship says, and it is your lordship's order of reference, but it is for your lordships to decide. And of course, the 39B point can get us home as much as the 31C point as well. So, my lord, that stands.
31B is essentially a validation provision. They wanted to validate certain things by virtue of that.
The 9th schedule. 9th schedule.
Prejudice itself.
Yes.
So it has a restrictive scope also. 31B has a restrictive scope.
Yes, my lord, what your lordship say, my lord, what resonates with me. In fact, that is our argument. Mr. Devarajan will make it for us. My lord, that actually, my lord, it is difficult to say that private property falls within 39B. My lord, that the so-called concurring judgment, it's called a concurring judgment, my lord, delivered by Justice Iyer, Justice Krishna Iyer, where he says that I agree with everything, but it's such an important issue, so I want to say something more on it. And my lord, he then slightly extends the principle in an axiomatic way to say that actually private property is obviously a part of 39B. And as your lordships have rightly pointed out, subsequent judgments have picked up that observation which was made by Justice Krishna Iyer. And my lord, if at all, my lord, the consequence, the impact on this case, if that it is not a part of private property, my lord, then a large part of our challenge, my lord, has a good chance of succeeding. So, my lord, that is how the impact lies on our case. And your lordship's absolutely right about 39B. My lord, I don't think I can say more on 31C. My lord, your lordship's interpretation of the reference order, of course, my lord, is, my lord, perfectly correct. My lord, I had only thought that the impact of Coehlo was something that required consideration by your lordships. Because my lord, the problem with Coehlo.
Just show us Coehlo.
Can I show it to your lordship?
Let's go to Coehlo because, you know,
But in the time left, my lord, will your lordship just have a look? My lord, I've prepared a very short note, but I wonder, would your lordship like to see the judgment itself? That might be better.
You have your note here?
I have a note where I've extracted actually, because all these judgments are so long. So I took the liberty of making some extracts. It's uploaded. It's uploaded.
Is it uploaded?
Yes.
Is it?
But it's It's actually comprehensive in the
Let's
sense that
take
it,
a note.
yes. So, my lord, if your lordship will, if, my lord, the court will kindly furnish your lordship, my lord, with an email sent by my learned friend, Mr. Parekh, my lord, at 9:56 this morning. We'll show the police one.
To 39B in that dichotomy, that 39B can never include private property. That will be very artificial, because when it says material resources of the community is agnostic to title. It doesn't mean that, well, where the title, it doesn't make that, distinction between a case where title vests in a private person as opposed to title in the community.
Or I see that point, right? Lordship is
So in a
right.
given case, take mines, for instance. They may be private mines, but in a broader sense, these are material resources of the community. The title may vest in a private individual, but therefore, for the purpose of 39B, our reading should not be constricted, but must have that broad understanding of 39B.
So, my lord, your political sense.
Or take a case like these buildings in Mumbai. Technically, you are right that these are privately owned buildings. But what was the reason for the law? We are not commenting on the legality or the validity of the law. That will be tested independently. The reason why the state legislature came out with this was that, these were all buildings, old buildings of 1940. With the kind of monsoon in Mumbai, these buildings get, dilapidated because of the saline weather. You know it better than me. Because of the
Only
saline
slightly.
weather. That, the fact that the rents were so meager that the landlords had no motive to at all to repair them. So where will the landlord, poor fellow, find any money to repair the buildings? And the tenants were sitting tight that no one tenant would have the wherewithal to repair the whole building. So therefore, the legislature had to. So these are, in a sense, what do you mean by material resources of the community? Material resources of the community would mean resources in which the community has a vital interest. If a building falls, the community is directly affected because who dies when a building falls? The occupants die. Therefore, we must distance it from a title.
Lord, there is no doubt that
Common good.
there is no doubt that it is not a question which is free from debate. Lord, and there is no doubt that these considerations have to be taken into account.
In bit of 39B, we have to answer as a bench.
But that is a specific point raised.
See, we were just discussing between ourselves. One way would be to say, accepting what the reference order says, that look, Ranganath Reddy didn't decide this issue. Sanjeev Coke was wrong in picking up on the judgment of the minority and then treating it as a bench of
As a majority.
Principle.
Yes.
And applying it in Sanjeev Coke. But even if assuming we do that, then what? The point still survives. And I think with this issue, we should resolve.
No, your lordship has to grapple with the issue substantively.
That 39B, the ambit of 39B is something which we should decide. That is the scope of the reference, in fact.
39C.
C is
The way we take it that Mr. Devarajan would be arguing that 39B cannot include private property at all. And you would be saying that it can.
It can.
Right? But
Yes.
obviously you will be addressing us as a matter of first principle also.
Yes, of course.
You're not going to only rest it on Sanjeev Coke because you will.
No. On first principles also. Lordship may decide the ambit.
Because we have to decide it. We are a bench of 9. We are not bound by any of these.
That's the reference your Lordship has to decide. And it will be better, but otherwise again this.
And there'll be some finality to this.
Yes.
Because what's the point in again having a ping pong bottle
That's
that
right.
will go before 7, then 7 will again have to interpret what Mafatlal meant. At least we in 9, we can at the least say that Mafatlal was obiter.
Yes.
And then decide it. We may still come to the same conclusion. But 7 can't, then 7 will be bound by even the obiter of Mafatlal.
So it may not be enough to say that Mafatlal is obiter and leave it at that and send it back. That may not be appropriate.
We will have to decide it.
Lordship may decide.
It's desirable that.
Yes.
Yes.
I thought we laid the cards very bare that, ultimately let's not again revisit the correctness of the constitutional validity of 31C on the basis that Coehlo would have some bearing on the correctness of what Because Coehlo was doing it in 31 in the context of 31B. Coehlo was bound by Keshwan Bharati.
No, my lord, I've consulted my colleagues also. And my lord, we have no objection either way. We are happy either way. If your lordship was to hear us, we are happy. If your lordship sent me home early, I'm happy with that.
No, nothing else.
My lord, on the other hand,
As an act of judicial statesmanship, we should be very careful about,
No,
opening
you-
up a canvas which may then have untold ramifications.
no,
on
my lord,
the
I
policy.
fully see that. My lord, I fully see the significance of the point. And we have some arguments on Coehlo, which we can run.
But you have put in so much of hard work. Why don't
No,
you
no, no,
show
my
us
lord.
your
I'm very
note on
happy to
Coehlo? In any case, there's something interesting.
I will show it to your lordship in a few minutes.
Your note. We'll
My lord,
see your note.
yes. And my lord, just to step back from that, so my lord, our position, my lord, we,
Opposing you have three academically oriented members of the bar, the attorney himself, Mr. Dwivedi, in any case,
In
Mr.
fact, the lighter side, I was telling them, all of us are material resource of the community.
The only issue is not to be distributed on the private side.
I think the compliment should be paid back to the bench, my lord.
There.
But
Resources is the question.
Home for dinner.
my lord, speaking for ourselves, my lord, we are perfectly content with that. My lord, we will argue the Coehlo point, my lord, before a smaller bench, once your lordship takes a view on 39. There's no problem with that. My lord, we have various ways to deal with Coehlo, so we can do that. There's no problem. If your lordship would like to see Coehlo, my lord, I'm happy to show your lordship what we have. On Coehlo. But it is actually a very, very interesting issue. It is a very interesting issue for more reasons than one. I won't take more than 20 minutes.
Yeah, of course. 31B, of course, creates an immunity for acts in the 9th schedule.
Yes.
But now, how do we apply the logic of Coehlo to 31C?
That is the point. Now, my lord, so my lord, let me address your lordship first on that.
Yeah.
So, my lord, as I pointed out to your lordship, that Coehlo and the question that is also framed there is actually a question which revolves around 31B. Now, my lord, some scholarly critique and criticism of Coehlo, Lord, has been precisely this, that it has not really answered the question with regard to 31B, at least to the fullest extent. But what Coehlo did was to make a very clear statement on what is included in the basic structure as far as these three rights are concerned, 14, 19, and 21. Lord, I think it would be open once again to some comment about whether it actually captured everything that it said in the judgment in the conclusion. Because in the judgment, it does suggest that in fact there are other fundamental rights which could also be entrenched in the basic structure, but it doesn't actually pick them up in the conclusion. Or the other aspect of Coehlo, Lord, which, Lord, with the greatest of respect, Lord, I say to the learned judges, Lord, they've laid out a very complicated test for testing 14 against the relevant law. Well, they've laid out two tests. Well, one is the rights test, and the second is the essence of rights test, which they draw back to Nagaraj's case, Justice Kapadia's judgment. Lord, when those two tests will apply is also alluded to in Coehlo, and Lord, it is a difficult to understand part of Coehlo, Lord, where the suggestion is that the rights test, which they also call the right stroke impact test, will apply where an entire chapter of the Constitution is abrogated, whereas the essence of rights test will apply to an individual article which stands affected or abrogated. What subsequent judgments of your lordship's court, Lord, have been, Lord, with the greatest of respect, a little cloudy about what exactly is the scope of those two tests also. But in my respectful submission, at least one judgment has mixed up the two tests as well, as I'll show your lordship. So, Lord, Coehlo itself gives rise to several questions. I fully appreciate the fact that this may not be the right forum to tackle Coehlo in its entirety, but perhaps my attempt today can be to show your lordship that an appropriate opportunity, Lord, there are some creases which need to be ironed out in the Coehlo judgment.
If you're taking 20
So,
minutes,
Lord,
let's look at your
I'll try to quickly deal with it, my lord. So, my lord, if your lordship will have a look at my note. On. Oh, yeah, here it is. Yeah, it's it. Lord, do your lordships have my note, my lord? Lord, so if your lordship sees the index of my note, Lord, it is Roman 2. And Lord, I've tried to make it comprehensive with regard to what I want to say with regard to Coehlo. I just want to show your lordship after that, my lord, 1 or 2 paragraphs in Coehlo, my lord, which are of particular significance. My lord.
Yes.
Lord, in paragraph 1, my lord, I've just set out, my lord, what your lordships have already read. Now, my lord, in paragraph 2, my lord, I've dealt with the
Yes, Mr.
Lord, paragraph 2, my lord. So, my lord, first is the reference in Coehlo. Why was it referred? The judgment in IR Coehlo.
Para 2, right?
Yes, para 2, if your lordships don't know. But it's at page 27, pagination, top right-hand side. It looks something like this.
Yes. Just go to para 2.
To para 2.
Just go to para 2.
So, my lord, we are on para 1. I follow, my lord, we can follow it here. Please scroll down to paragraph. Yeah. My lord, the judgment in IR Coehlo. Notice that there were apparent inconsistencies in the judgment in Vaman Rao and Union of India, in particular between the judgments of Chief Justice Chandrachud and Justice Bhagwati. See paragraph 3 of IR Coehlo Supra. Accordingly, the 5 judges in IR Coehlo stated that the judgment in Vaman Rao needs to be considered by a larger bench so that the apparent inconsistencies therein are reconciled and it is made clear whether an act or regulation which or a part of which is or has been found by this court to be violative of one or more of the fundamental rights conferred by Article 14, 19, and 31 can be included in the 9th schedule, or whether it is only a constitutional amendment amending the 9th schedule that damages or destroys the basic structure of the Constitution that can be struck down. So your lordship notes the question as formulated. It's slightly changed when the 9 judges actually dealt with it. Further, the 5 judges in Coehlo also noted that the decision in Bhimji Singh Ji case will also have to be considered by the larger bench for the purpose of arriving at a conclusion aforementioned. Now, just by way of a temporal context, your lordship is aware, Lord Vaman Rao, Minerva Mills, Lord 1918. Lord Minerva Mills, July 1980, Vaman Rao, November 1980. Lord
Definitive order pronounced on the same day, 9th May 1980.
Exactly, my lord. Interim order pronounced on the same day, reasons given separately, but one before the other. But unusual of great academic interest for various reasons, my lord. Magisterial dissent by Justice Bhagwati in Minerva Mills, picked up as Sanjeev Kok, as your lordship notes. Lord Vaman Rao, my lord, deals with the unamended Article 31C, upholds it not because of Keshavnanda Bharati, but on independent reasoning, which is in parity with upholding Article 31A on agrarian reforms. Lord, on the other hand, my lord, in Minerva Mills, Lord, an interesting point, my lord, that the Sikh Industries Act, which was challenged there, was actually an act which took effect prior to the amendment to 31C. But yet 31C was struck down, Lord, on the annual of 14, 19, and 21. And Lord, I think that is what is referred to broadly also in this. Now, my lord, the judgment in IR Coehlo. And I've put here, my lord, actually, my lord, what the question was and the facts to allow us to actually understand what was decided. The matter was duly referred to a bench of 9 judges. The judgment is reported in so and so. The challenge before this High Court was that the Gudalur Jannam estate abolition and conversion into Rayatwari Acts 1969, insofar as it vested forest lands in the Jannan estates in the state of Tamil Nadu, was struck down by this court in the Balmadis Plantation Limited because this was not found to be a measure of agrarian reform protected by 31A of the Constitution. Section 2C of the West Bengal Land Holding Revenue Act 79 was struck down by the Calcutta High Court as being arbitrary and therefore unconstitutional, and the special leave petition filed against the judgment of the state of West Bengal was dismissed. By the Constitution 34th Amendment Act, the Janvam Act in its entirety was inserted in the 9th schedule by the Constitution 66th Amendment Act. The West Bengal Landholding Revenue Act in its entirety was inserted in the 9th schedule. These insertions were the subject matter of challenge before the 5-judge bench. So, the very troublesome aspect of the 9th schedule was that after a court had set aside a statute, despite the constitutional basis of it being set aside, not being altered by Parliament, they could simply validate it by putting it into the 9th schedule. Well, that has been long the criticism of the 9th schedule. But the contention urged before the Constitution bench was that the statutes inclusive of the portion thereof which had been struck down could not have been validly inserted into the 9th schedule. The judgment, now the question, your Lordship will immediately notice a slightly different question from the question referred. My Lord, the fundamental question, Lord, as my lady pointed out, Lord, on and after 24th April 73, whether the basic structure document was propounded, it is permissible for Parliament under Article 31B to immunize legislation from fundamental rights by inserting them into the 9th schedule. And if so, what is the effect on the power of judicial review of the court? So the question frame, not against me on the 31C point, is that it was squarely a 31B question which was framed. But my Lord, please see now how it was answered. Now, my Lord, I'll take your Lordship straight to the conclusions, my Lord, longish judgment, 150 odd paragraphs. In conclusion, we hold that a law that abrogates or abridges rights guaranteed by Part 3 of the Constitution may violate the basic structure doctrine or it may not. So, my Lord, not every part of Part 3 is a part of the basic structure. But a classic example, what I've often puzzled about is 18, my Lord, titles. Lord, it seems to be an odd inclusion in Chapter 3, but it seems to be strange to say that it is an inalienable human right, etc. So, Lord, they've noticed that. They've said not every part of Chapter 3 is actually entrenched. If the former is the consequence of law, whether by amendment of any article of Part 3 or by an insertion in the 9th schedule, such law will have to be invalidated in the exercise of judicial review power of the court. The validity or invalidity would be tested on the principles laid down in this judgment. The majority judgment in Keshavananda Bharati, read with Indira Gandhi's case, requires the validity of each new constitutional amendment to be judged on its own merits. The actual effect and impact of the law on the rights guaranteed under Part 3 has to be taken into account for determining whether or not it destroys the basic structure. The impact test would determine the validity of the challenge. Now, the impact test is viewed what's called interchangeably the rights test or the impact test. But Roman 3, all amendments made to the Constitution after 24th April 73, the date of Keshavananda Bharati, by which the 9th schedule is amended by inclusion of various laws therein, shall have to be tested on the touchstone of basic and essential features of the Constitution, as reflected in Article 21, read with 14, 19, and the principles underlying them. To put it differently, even though an act is put in the 9th schedule by a constitutional amendment, its provisions would be open to attack on the ground that they destroy or damage the basic structure of if the fundamental rights or the rights taken away or abrogated pertain to the basic structure. Justification for conferring protection, not blanket protection, on the laws included in the 9th schedule by constitutional amendment shall be a matter of constitutional adjudication by examining the nature and extent of infraction of a fundamental right by a statute sought to be constitutionally protected, and on the touchstone of basic structure doctrine as referred to in Article 21, read with 14 and 19, by application of the rights test. Now, here comes the second test, and the essence of right test, taking a synoptic view of articles in Part 3 as held in Indira Gandhi's case. Applying the above test to the 9th schedule laws, if the infraction affects the basic structure, then such laws will not get protection of the 9th schedule. This is our answer to the question referred to us, Vide Order 14-999 in IR Coehlo and State of Tamil Nadu. So, my Lord, so far, my Lord, it would be difficult to say that this is a 31C judgment. This is very much a 31B judgment. I fully appreciate that. Lord 5, if the validity of any 9th schedule law it has already been upheld by this court, I'm so sorry, my Lord, small error, it would not be open to challenge such law again on principles declared by this judgment. But that was the pernicious effect of 31B. Lord, however, if a law held to be violative of any rights in Part 3 is subsequently incorporated in the 9th schedule after 24th April 73, such a violation infraction shall be open to challenge on the ground that it destroys or damages the basic structure. As indicated in Article 21, read with Article 14 and 19, and the principles underlying thereunder, action taken and transaction finalized as a result of the impugned acts shall not be open to challenge. Now, my lord, some of the salient features are set out here. My lord, before I go to the salient features, my lord, your lordship knows enough of the judgment. My lord, just to take a view, I'll take your lordship to my submissions on this and come back. My lord, the salient features, my lord, I must confess to plagiarism, my lord. I've taken them from my learned friend, Mr. Devarajan's note, which he had kindly shared with me, my lord. My lord, he had done such a masterly job of it, my lord, I saw no reason to alter it in any way. My lord, may I take your lordship, my lord, straight now, my lord, to the conclusions that I have drawn in paragraph 9. But I'll come back if necessary to the salient features. But more broadly speaking, what the judgment does is that it broadens the defense that is given by fundamental rights. Lord, it is said it is no longer an isolated pools. It should be viewed as the principal controlling influence over the amending power. So, Lord, that is the broad thrust of what this does. Lord, there are certain observations with regard to 31C I'll come to. Now, Lord, the conclusions I have drawn, Lord, are these. Well, the conclusions that can be drawn from the judgment in IR Coehlo as stated below. When a law abrogates or abridges rights granted by Part 3 of the Constitution, it may or may not violate the basic structure doctrine. The test to be applied is either the rights test or the essence of rights test. The rights test is as under. First, the court must test whether there is a violation of Part 3. And second, if such a violation is found, its impact must be examined in terms of its effect and substance to see whether it destroys the basic structure of the Constitution. In the event it does, then I quote, invalidation has to follow. The essence of right test is explained in M. Nagaraj's case. Within Part 3, 14, 15, 19, 20, and 21, your lordship noticed that this was not recognized in the conclusion, but it is in the body of the judgment, are recognized as a part of the basic structure. The validity of 31A and 31C were not questioned and accordingly expressly held to be valid. Now, Lord, this is the interesting observation, despite the denial of Article 14. And on the basis that these articles have indicia, which is not there in Article 31B. Now, my lord, some observations on the impact on the present case. And my lord, your lordship will take all of this in the spirit that, my lord, I accept what your lordship say, and my lord, it may or may not be decided by your lordships. My lord, applying the essence of rights test. My lord, essence of rights test, my lord, slightly different from the rights test. My lord, summarized to mean that we must go behind the principles with each of the fundamental rights. My lord, I had thought, my lord, that a reference to essence would be a narrowing down of the right, but actually it is a broadening of the right. What it says is that we must go by the principle of the right. So we must read the Constitution as a whole for that. So Article 14 should not be read, for example, in a formalistic manner, but we must read it in a broad manner in accordance with the spirit of Article 14. Applying the essence of right test since 21, read with 14 and 19, the principles underlying them have been held to be a part of the basic structure. Article 31C, insofar as it is inconsistent with or abridges rights under Article 14, destroys the basic structure. Even applying the rights test, the same result follows. Accordingly, the consequence, now, my lord, is that invalidation of 31C has to follow. Now, my lord, this is controversial, I see that. But what, let me set out my thought process for your lordship. There was no challenge to 31C in IR Coehlo. The statement with regard to 31A and 31C and the fact that they differ from 31B should be understood in that context. In the present case, the question of 31C squarely arises, and other things being equal, but what I mean is if you exclude Keshav Nanda, etc., and subject to what is stated below, it is open to this Honorable Court of 9 judges to examine the validity of 31C. This is especially so as Coehlo has observed that 31C results in a denial of Article 14. The determination of the validity of 31C in Keshav Nanda Bharti is, however, binding. 31C was upheld by a majority of 7 judges, 6 judges, and 6 judges as, Chief Justice Ray, Palekar, Dwivedi, Matthew, Beg, and Justice Chandrachud, as he was then, held that it should be upheld because of the amending power of Parliament was absolute and unlimited. Justice Khanna, even on the basis of the limited power to amend, upheld the validity of Article 31C. In this regard, see Justice Bhagwati in Minerva Mills. But he has done a masterful analysis of this aspect. The impact of the judgment of Coehlo is, however, to render 31C without any force. the validity of 31C, while binding, is a matter of precedent, is depleted of purpose. Now, my lord, there's some follow-up also, my lord, which is there. Follow-up all concerns the test, but if your lordships are not going into it, or it may not be very relevant. So, my lord, this is the issue with regard to Coehlo. My lord, with the greatest of respect, my lord, obliged, Your Lordship. Deeply obliged.
Thank you, Mr.
Deeply obliged.
Yes, Mr. Devaraj. Now, you are going to be arguing the 39B point basically.
Yeah, they have noticed that. So, obliged.
What did I say?
With my Lordship's kind permission, my Lords, before I attempt to interpret 39B, I would request your Lordships to have a look at section Article 39. The state shall in particular direct its policy. My Lords, our case is that if it's a policy of the state, it can't be restricted to a few wards in a municipal corporation. That's our first case. Our first point is on the question of policy.
That may be a ground to challenge the act.
The act is under challenge, my Lords.
That is before the bench which will hear the challenge to
So
the act.
I go before your Lordships, but when it comes to an interpretation, my Lords, one point that your Lordships have repeatedly been saying that if we feel that it's an academic question, we will not decide it. The point I'm trying to make here is twofold. One, before we go to question whether private properties would be material resources of the community or not, the question that we need to consider is what is material resources, one, and two, in respect to the matters before your Lordship, is there a material resource? I fully bow to what my Lord the Chief Justice said. We are not entitled to the property. We are on whether it's a resource of the community. My lords, again, the question here is not just resource of the community. Is it a material resource of the community? I'm emphasizing the words here, my lord. I'm on policy and I'm on material resource. Before I come to the question whether private can be included or not, this question might kindly be considered.
Must also bear in mind,
Please.
material resources of the community is in the context of distribution.
I bow before your lady. I bow before your ladyship's suggestions, my lady, because our case further, when we go through, I will take the liberty of taking your lordship through the act. Only that's chapter 8A, because that might clarify quite a few points. Is there a distribution of control? Is there a distribution of material resources? Now, material resources, once I can zero down and say that material resource should be that resource which produces goods or services for the community. If it does not produce goods or services, it would not fall within the category of material resources. That is my humble submission for your lordship's kind consideration. Here, my ladies, what is the situation? The situation is that a cess was levied on these landlords and tenants for carrying out structural repairs. The state says it is our duty to carry out structural repairs. When I say state, my lord, I refer to the board. If they don't carry out structural repairs, they don't give me the wherewithal to carry out repairs, my rent is frozen at 1940 levels, the cost of all building materials, construction materials are shorter, and I'm not put in a position to carry out repairs, would such buildings form a material resource, much less that of the community? This is a question which I would try to satisfy your lordships, that this is not a material resource, much less of the community. That's the first.
Clause B has 4 aspects. The primary aspect is material resources of the community. What is it dealing with? It is dealing with the distribution of the material resources of the community. What facet of distribution is it dealing with? It is dealing with ownership
and
control. Because are so distributed qualifies ownership and control.
Correct.
Ownership and control of what? Of the material resources.
And for what purpose?
Distribution of what? Distribution of the ownership and control of the material
resource. Now we are.
Now, what is the object? To subserve the common good. And the fact that the legislature, that the constitution uses the expression ownership and control is very significant. Ownership refers to the title or the vesting of the title. Control is much broader in its understanding because it's not confined to title.
Here, my lords, I'm raising 2 issues for your lordship's kind consideration. The first, as I already indicated, my lords, when the constitution says that the state policy of the directorate's policy, now would it be only for the city of Bombay? Would it be only for the district of Nasik, or should it be that policy should be over the state? This is the primary question.
That wouldn't worry us because then the state can always make an under-inclusive classification. Yes. Then you say that, look, the condition of the buildings in Mumbai is so unique that you don't have to legislate, you don't have to regulate the entirety of the state. That the state can easily, that is not an issue at all.
My lords, if it were a regulation, my lords, I would have bowed to your lordship's suggestions immediately. But here it's not a regulation, my lords. Here it's not a regulation.
So, we are not so much today interpreting the provisions of the statute as we are interpreting the expressions of clause B of Article 39.
I go to what my Lord the Chief Justice has said, but I request my Lord the Chief Justice to kindly consider whether we could interpret this, dehouse the facts before us. Because this question has come to your lordships on the basis of certain facts which were there.
But when we are interpreting Article 39B, we don't interpret it in the context of that statute today before the bench of 9 judges.
I would request your lordships to kindly consider
whether
it.
there is a dichotomy between privately held property and publicly. For instance, will 39B cover only those lands which are what you call in Maharashtra Gairan lands or the grazing lands? Or would it also cover in certain cases private
Only
property?
one interjection with so that your lordship's discussion can also be suitably. Resources, psychologically because of MHADA and Rent Act, we are considering land and building. The resources would mean several mines, minerals, airwaves, etc. Several things.
Natural resources as well as man-made resources.
Yes, exactly. Not just land or buildings. That also may be one of the focus of examination.
My lord, I have no difficulty in the term resources. I have difficulty in this, in submitting to your lordships that my building would be a material resource. Because your lordships have time and again held. Sorry.
What are these about?
So Devarajan, is that, look, the MHADA Act contains a declaration that it is intended to give effect to the directive principle contained in 39B. Your contention, I mean, we are just trying to understand your argument. Your argument is that, look, you could not have made that declaration because 39B cannot, by any standards, extend to private property. I think that's your,
No, my lords, my submission is slightly wider than that. What your lordship says is one part of what I'm submitting. My second part of it is, before you could make such a declaration, because your lordships and Keshananda said this is justifiable.
Make a declaration.
Before you make a declaration, you must come to the conclusion that it's a material resource.
Obviously.
I'm on that. I am trying to make a submission.
According to this can't be material resource.
According to me, it can't be a material resources. Old dilapidated buildings cannot be material resource of the community. This is my submission.
Questioning the declaration itself.
In a way, my lady, in a way, I'm trying to interpret 39B to say that before 39B can apply and the subsequent things can follow. Yes, what I interpreted, as my ladyship said, I need to go through the act to interpret the rest of 39B.
But why can't?
But I'm not going there.
Why can't it be interpreted like this, that any building, old, we are not dealing with a building. Buildings which are in the occupation, old dilapidated buildings in, say, like the island city, which are in the occupation of a large mass of occupiers and tenants. They constitute a part of the material resources of the community because ultimately it's a source of habitation and abode for such a large group of citizens.
My Lord the Chief Justice, I go to what your Lordship said, but my Lords have time and again said, made a distinction between a resource per se and material resources. This is where I would try to convince your lordships that yes, this is a resource, but is it a material resource?
Just one,
I'm sorry.
add to what the Chief Justice has asked you. The material resources of the community, when you look at that expression, are we not also looking at the community of inhabitants in a dilapidated building?
Please, madam.
Because if you look at their need, a building is crumbling down, a building is no more safe. So, community who are occupying that building, it is a material resource and a vital material resource for them.
Again, my Lord, I could not make my point clear.
No,
That it is a resource, the petitioners don't dispute. The question is it a material resource? Because your lordships have said, for a resource to be a material resource, it should provide goods and services for the community. What is my building doing so?
It provides a service. What is more fundamental than the right to housing?
No.
It provides a place of abode
No,
for such a large segment of the community. Take a building which has, say, 70 occupiers or 40 occupiers. It's a community, as Brother Rishikesh Roy says, that it's a community of occupiers.
Why the community will have to buy it?
for these communities.
Absolutely.
Yeah, you just continue.
Get to it.
Please, my lords.